Welcome to this episode of Live with Lazidi, powered by the China Project. Today, joining me is Benjamin Chu. Benjamin Chu is a partner with the law firm Loeb Loeb. He handles venture capital financing for Chinese companies and others. Benjamin is also a registered arbitrator with the Shenzhen Court of International Arbitration. Thank you so much for joining me, Benjamin.
Thank you. Glad to be here.
So, Benjamin, you recently penned an article for Nikkei Asian Review on China's anti-corruption agency now having its financial sector in sight. So that's what I want to discuss with you today. As you know, Central Commission for Discipline Inspection, China's top anti-graft agency, has recently criticized the so-called financial elitism and called for a crackdown on the financial sector. What's your read on this? Who are the people that the CCDC is targeting?
Sure. As a lot of people have noticed, the anti-corruption campaign in China has been ongoing for around 10 years. And all sectors, whether it's power, energy-related SOEs, state-owned enterprises, or car companies, including banking systems, have been under review for several years in the past. And my reading of this is we might be looking at the start of the anti-corruption campaign 2.0, because CCDI is a very powerful anti-corruption arm of the party itself. It's strictly speaking not an arm of the state council of the state, but of the party, and they have access to all kinds of tools to detain, interrogate, investigate any targets. And in the past, most of the targets tend to be, some persons or companies relating to state power, government officials, or state-owned companies. But now, this new article that came out a week ago from CCDI broadly criticizes cronyism, all kinds of questionable gray zone type of corruption practice, such as the political business revolving door phenomenon, and also down to the personal lifestyle of financial professionals, presumably relating to government officials or state-owned company employees. But it's not clear. We might be looking at a broader campaign where business people mingle with governments officials, and then they go to dinner, then or go to a yacht in Hong Kong. None of those seems to be going to be tolerated anymore. And it begs the question: why be a financial professional if you cannot live certain type of lifestyle?
Fascinating. In the article, you also talk about the practice of serving as another party's nominee for corporate holdings. Can you talk a little more about that? How prevalent is that practice, and why is it potentially problematic?
Sure, it's very prevalent, and there's nothing illegal about it. It's permitted under the PRC law, and oftentimes it's for completely innocent reasons. For example, a founder may be holding a foreign passport, and a company that person has interest in China, by regulations, cannot have a foreign shareholders, and that person asks a co-founder or his or her family members to hold shares on that person's behalf. It happens all the time. Or oftentimes, there's some wise or influential person who has helped the company, and then out of gratitude, the company decides that that person should be allocated a certain number of shares in the company, but because that company has some other full-time job, or that person holds a foreign passport, and then the founder or somebody holds the shares on behalf of that person. That happens all the time. But of course, it becomes questionable and potentially a corruption issue if that person is current or recently retired, let's say, a government official who has influence in this sector. So that, going back to the CCDI mandate, it broadly talks about cronyism, having influence, and at the same time speaking out on behalf of the certain quote unquote interest groups. On one hand, if you are looking at a government official potentially holding shares in a company in a corrupt situation, of course, that's probably wrong. That should be undone. But oftentimes, companies have legitimate reasons to talk to officials, regulators, decision makers. What if the companies or certain activist groups have comments about environmental regulations, about labor regulations? There will be quite some chilling effect on those.
I see. As you briefly alluded to, Beijing seems to be tightening its leash on financial market players. Again, anti-corruption 2.0. Now we heard of news of the detention of high-profile bankers like Bao Fan. What's the implication for private companies? How are they feeling now?
Well, the implication is huge. On one hand, he's not the first person in the Chinese business world or financial professional world in particular that has been detained in a completely in a situation that's completely without transparency or due process. But I'm a little bit older. I'm not sure many of the viewers here recall that right after the Silicon Valley .com bust, probably the top American banker, sort of, people sometimes on the market try to flatter Bao Fan by saying he's China's Frank Quattrone. Frank Quattrone was a Credit Suisse banker back in the late 90s, made a lot of deals in the Silicon Valley, and some of the practice became questionable. And of course, some people would argue, or his lawyer would argue, that after the .com bust, some people will, the regulators want to make example of some people, and he got into a number of legal troubles. But but that's where the difference really starts. Well, he has lawyers. He went through the process. He had his lawyer had a plea bargaining with the federal agency enforcement, and he never served any jail time. And sure enough, since quite a few years ago, he had a quite successful second start of his financial deal-making career. So, we're all watching this, because if you are an investor who invested in some of the top technologies companies in China the past 5 to 10 years, chances are Bao Fan or China Renaissance was involved in the deal. Then you would be very nervous. Well, what would happen to your deal? Would that be ordered to unwind? What would happen to the company that you invested in? And most importantly, who will be the next? Bao Fan was involved in a number of deals in recent years, including DD and many others. All those founders must be asking the question now. Even before his arrest, a lot of the founders from China are asking each other vocally, what's the point of getting rich if the accountability and transparency are still not there yet? So the people asking those questions will just be louder now, or they're not asking, they're just moving their money and their family and their company out of China.
Right. Speaking of this lack of transparency, a lot of people in our audience are wondering, what are the regulation changes or the most updated regulations regarding, overseas stock market listing? There's been a lot of chatter about rules being changed, rules being tightened. And, what's the future of VIE structure?
Sure. Well, in theory, the future of a VIE structure is bright. As a lot of people know, well, first of all, for those who are not familiar, VIE structure is essentially a fairly complex onshore plus offshore. By saying that, I'm talking from China's perspective. Onshore plus offshore company structure, which includes what we call a variable interest entity, meaning a company registered and operates in China as part of that overall structure. So, by going through that kind of costly and complicated structure building, the goal for a company having that kind of structure is generally to get around the tight foreign currency control from Beijing and also the regulations about overseas financial transactions, including IPO, the initial public offering, going public in an overseas market. So the CSRC, the China Securities Regulation Commission, securities regulator, published a bundle of rules, which will come into effect March 31st, end of this month. Essentially, part of that really clarifies that the VA structure is legitimate. It's no longer considered, implied that it's no longer considered a way to just to get around Beijing's regulations. And it doesn't add any additional barriers in the form of approval. It just says you need to register your plan to go public overseas, and then you can do it. And then you need to periodically report to the Beijing regulators. So in a way, it's a very good news. At the same time, after the zero COVID policy comes to an end, Beijing seems to be making many efforts to reopen the economy. And today's Chinese companies are still hungry for foreign technology and capital and expertise that comes with those foreign capital. But of course, the question is how many companies will be too nervous to still try to raise funds or go public overseas, considering what happened to DD and Ant and several other companies. We're just talking about the prominent cases. Those cases definitely had a chilling effect because people will be saying, okay, so VIE structure is considered legitimate now. China, well, still is hungry for technology and capital, but so what? Look at Baofan, look at the demographics, look at the overall sentiment of the founders and entrepreneurs from China. So we have some question marks. We'll see.